Joining me now is trial attorney and legal analyst Misty Marris. Misty, thank you so much for your time. So she's saying that she's been silent. It's time to speak up. She's proclaiming her innocence. As an attorney, what would you be advising if Kouri Richins were your client?
I actually thought this was pretty interesting that this statement came at this time. Nichole, keep in mind her defense team just recently withdrew from the case due to a conflict of interest. So I imagine her defense team had told her previously, stay quiet. That's always the best advice, because come the time that you're actually in the courtroom at trial, any public statements that are made could absolutely come back to haunt you. Now, her statement was pretty innocuous. She didn't really get into any details. However, it's always the best advice to keep quiet and maintain that silence throughout the trial while your defense team makes a determination about whether or not she should testify.
All right, so you mentioned the fact that her defense team has withdrawn from her case. Just talk about what that could mean for her going forward.
I think it means that this case is probably going to be punted until maybe the fall. So right now, her preliminary hearing, and that's the hearing that comes before trial. At a preliminary hearing, evidence will be presented and a judge will make a determination about whether or not there's enough evidence to actually go forward with the trial process before a jury. And so that's scheduled to take place in June. But her defense team now has withdrawn from the case. The judge approved it. And so it's going to take a while for another attorney or law firm to get up to speed in order to conduct that proceeding. And Nichole, I'm wondering, because her defense team is no longer in place and she's likely searching for a new attorney or a public defender, that's why we heard this public statement. This could really be in the oblivion for a bit. We might not see this case go to the preliminary hearing until September, October.
So I want to dig into this sound that we're hearing from Kouri and her former lead defense attorney, who alleged that prosecutors were improperly obtaining evidence, including jail calls, which is how this recording came out, and also a letter because it was considered confidential because of attorney-client privilege. So there was a motion to disqualify the state prosecutors. There's so much going on here, but do you think there is a legitimate case for that?
So much going on in this. So that's actually an incredibly serious issue. Any jailhouse phone calls are actually fair game, except when they're protected by attorney-client privilege. And the ability for an attorney to communicate freely with their client while they're behind bars is paramount to the criminal justice system. It is a right and it should be privileged. What prosecutors have argued is that the defense attorneys actually did not do something procedurally, which in their position, the prosecutors say the defense attorneys acquiesced and waived privilege. And that's that there was a specific app, an app on the phone that defense attorneys were supposed to use and download that would call out the privileged calls and separate them from other calls that were made, which would ultimately be fodder for prosecutors. So they're actually basing this on a technicality. But if in fact a privileged attorney-client documents or attorney-client communications were intercepted by prosecutors, one thing is to get them disqualified, and it sounds like the judge isn't going to go for that, but the other part is none of that should ever see the light of day in a courtroom. So a technicality versus the rights of a defendant, I think you're going to see that evidence being excluded.
Yeah, there is so much to this case. Misty, thank you so much for your time. Certainly appreciate it. Have a great weekend.
Thanks, Nichole. Happy Memorial Day.
Thank you. And as many people are